2011. Unfortunately, I will be unable to attend the meeting due to personal circumstances, and we request to reschedule my application for the next meeting session. I thank you in advance for your understanding and apologize for such short notice. Michael Baganis, 119 Wood Lane, Wayne, Pennsylvania. Anyone have a problem? Okay. Okay. Continue till the next scheduled meeting, which would be the third Thursday in November. Just for future notice, we only accept signed requests. So anyone that is requesting a continuance, either they have to show up or send us a faxed or a scanned letter signed for us to acknowledge that, just to put that on the record. Okay, appeal 2862, which was continued from the September meeting. Applicant 134 Partners LP, property located at 134 North Wayne Avenue in Wayne, Pennsylvania, Zone WBOD. Applicant requests approval of their building identification sign height as approved by the Design Review Board. Pending zoning appeal per code reference. Section 280-122C2, no wall sign shall exceed a sign height of 15 feet above the existing grade. Section 280-5315, B and D, no projecting sign shall be lower than 9 feet above grade or higher than 12 feet above grade, and no projecting sign may be larger than 4 square feet. You're on, sir.
Good evening.
I should swear them in.
Yes.
Will you both be testifying?
Yes.
If you'll both raise your right hands, I'll swear you in.
Here.
You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes.
Okay, and state your names one at a time,
Brad Palmer.
Greg Brzezinski.
and spell
Here.
that.
Berzinski.
Thank you.
In case you split your, so you can both talk at the same time.
I'm Brad Palmer. I'm one of the owners of 134 North Wayne Avenue. This is Greg Brzezinski of Brzezinski Architects. He's the architect on this project. And we're here on an appeal for the signage for 2 identification signs for this building. One is falls under the description of a wall sign, and one sign is a projecting sign. Part of the context of this appeal is the redevelopment of an historic storefront and our work at doing some redesign that adapts it functionally for new use and remains as sensitive as possible to the historic elements on the building that are visible from the street, and being able to bring those forward, preserve them, or add to them in a way that contributes to the aesthetic of this building to the commercial district there. And in doing this, some of the redesign pieces needed some additional creativity and some solutions that we feel are appropriate in their functionality and their aesthetic, but as you see, don't conform to this piece of the code. We took these signs to the Design Review Board in August, and the Design Review Board reviewed them as we're presenting them to you. They liked them very much and commended them. They tentatively they recommended approval, but called out that there were these issues with conformity. And we can address signs then one at a time, or do you have any other?
Yeah, why don't you work on one at a time? You're asking for two signs. There's
Correct.
the one at the Suburban at the top,
Correct.
okay, and the Suburban on the left-hand side, as
That's
you look at
right.
it on the screen, correct?
Right.
Was that Suburban sign ever up there, or was there ever a sign at the very, very top?
The original brick facade has been covered over by stucco,
I don't know why I thought that I'd seen a sign up there in years.
and there underneath the stucco there is an original limestone element that wasn't engraved with any name on it. But what's
So
typical?
you're kind of replacing the sign that was there.
Well, it's typical of buildings of this era is that they have that, so,
Yes.
yes. This will,
Yes.
Okay. Why don't you start going one sign at a time? I think that'd be best.
okay, thank you. This suburban sign on the top, Greg, you want to address this one? Thanks. Obviously, this sign sits above 15 feet above grade. The canopy in the front goes up to about 12 feet. And then you have the windows, and they're really, in order to work with the historic facade the way it is, there isn't any place else to put that sign back on the building.
If I could just add, as you noted, I mean, there was a plaque up there.
Make sure you use the microphone, please. Thank you.
Since the previous marker on the top of the building was covered with the stucco, this suburban sign is really trying to emulate what was probably there underneath, picking up the cast limestone details that are on the side of the building. So doing this sign in a cast resin material, which will look like the cast limestone that's on the building. The letters would be incised, fairly subtle. As you can see on examples of other buildings of a historic nature around town, this shows the post office building with a similar incised letter that we would be recommending.
Will this be illuminated, this sign?
This sign would not be illuminated. It's strictly a building identification marker.
It would have the option for illumination. I
Sorry.
think it was presented at the design board with the possibility of being illuminated with low,
It probably wasn't illuminated in the past.
not internally illuminated, but
Right.
just like a little in front.
Questions about this specific sign? Brad, Noah, Jim?
Am I missing something? How far up is this sign from the street grade?
You said that.
The sign's probably about 26 feet above the street, located in the parapet area. The sign itself measures about 21 inches by 109 inches in width.
It would be as per the A11 plan, right?
Correct.
And the A12 plan. Yeah, there you go. They've got the dimensions of the sign. I think because if it's a scale drawing, you could measure exactly how high up it is, but it'd be better to have had the measurement right on the plan.
It's.
You didn't exceed the total square footage of allowable signage,
Correct.
do you? No?
No, all of the signage was planned for the east facade, which would include all of the markers which are represented on the drawing, from window decals, identifications for each of the potential tenants, as well as the suburban, 74 allowable square feet on the
Okay,
facade.
you're below
and
that.
They all fall
Okay.
within that. And that was, I think there's a drawing in your package that shows that. It's this sheet here, 74 total allowance, and sign C is called out there, is 15 square.
What drawing is
That's
that?
not in their packet.
I'm sorry, it's not it?
No, the one he's referring to isn't in the.
It's not in the packet. I was going to,
Okay, sorry.
And the one he's referring to is the signage plan with call-outs on
Can you try to
signage allotments.
I have trouble here.
I'm sorry.
you want to take this other one, and, just in case?
Is it, can you hear me through this
I
one?
can hear you, I can't.
Okay.
I think I turned it on.
Is A12 the blade sign?
Yes.
Oh, okay, so I was wrong. A11 is covers the top sign, and A12.
A11 is the top sign, John.
Okay, it's a blade.
It says elevation 15.1 feet. Is that right?
Mm-hmm.
So you're what? You're 0.1 foot over what you need? Is that what-
That's actually describing the size of
Oh,
this sign.
Okay.
All of the signs on this facade fall within the square footage allotments. It's
No,
really-
no, I'm saying the elevation. It says elevation is 15.1.
Yeah, I think that term is meant to describe,
The square footage of the sign piece.
Charlie, I think if you look at A8,
Okay, I was looking at A11.
yeah, A8 has some elevations. It has it up to the top of the third floor, which is 21
21?
feet 2 inches. So it's
Okay.
a little bit
Yeah,
over
if
that.
you look at A11, it says right below it, elevation, and you assume it means elevation.
yeah, that's confusing, I'm sorry.
Okay. Okay. All right, the other sign, all right, any questions on this one? Okay,
Okay, the other sign is page A12 in your packet for a sign detail. And
You wanna look at that?
And if you like, Greg could keep the rendering up on the screen. This sign, the context for this sign is the redevelopment of the building and readaptation to new use, and the need to provide accessibility to all the spaces in this building. The design solution for that is the new main entrance and lobby that you see underneath this proposed blade sign. And that entrance and lobby provides accessibility to all the spaces in the building, through the lobby, through the elevator. And so,
over here.
in moving
Here,
the main
over here. Right.
entrance to the side, it's necessary for a building, for the identification sign to provide a visual reference to that entrance on the side of the building. And that's the reason for the sign being there. And then the sign, in terms of its size and height, it sits back, as you can see in the perspective drawing, from the sidewalk. It's in an appropriate scale, and so in order to get its functionality being visible so that that's known as an entrance to the side of the building, that's why that's how the sign is positioned. That's why it's up as high as it will be, and as the size and scale that it is.
I'm trying to remember when there was some discussion when you were here before about this alleyway, which is access to deliveries for the other establishments, if I remember correctly.
Yeah, it's a shared pedestrian
Right.
and vehicular way.
How wide is that alleyway?
I have that on the plan here.
I think it's 13 feet 9 inches. 13 feet, I think. The alley portion, I think, is 10, and then there's a 3-foot setback from our building facade.
Is that going to propose a problem for delivery trucks?
Which part of it are you thinking about?
I'm just worried about, well, I mean, you have the little pent roof, is that what it is?
Yes.
Okay, I mean, how far does that stick out?
It sticks out 2 feet 3 inches from the building.
And the sign is what? The sign is inside that? The sign
The
is how
sign
wide?
is, yeah, the width of the sign is 2 feet 3 inches also.
It's the same.
And what's the height from grade to the bottom of the pent roof?
It's 13 feet 9 inches. Modification on site due to grade issues. It's called out as 12 foot 10 on the drawings. It's been raised to 13.9.
I'm just concerned, I mean, I'm more concerned with a truck hitting that, with its height from grade. I mean, I'd be
We
more,
looked at all the semis, and it falls under all of semi-trucks. The largest truck that could possibly be back there, which would be an 18-wheel semi-truck, is under the 13.9.
it's under 13? Okay.
Yeah. Which is a concern of ours that
Yeah,
go to the
I just,
trouble to,
I
put up this.
mean, all it takes is one truck to hit it, and
Exactly.
it's coming down, sign and all.
That's good thinking. That's why we put it above the height of any
Right.
vehicle that could go back there.
Okay. Have you anything else?
So, just what Brad was saying, this, the sign as a blade sign is seen. This is actually traced over a photograph standing about the middle of the road, the middle of the street on North Wayne. So it seems to us in proportion with the signs of the building itself, and we need to get the identification for, there's potentially 9 tenants that'll be in this building, and this is the accessible entrance, being able to get them to that location. This is also the only sign that would be on this block, since our property goes from the street back to the end, so there's no potential for any other tenants to have a blade sign on the side of the street.
Is the height from grade that the sign ends at that roof, are there windows there that you're designing around also, underneath the
It
roof?
fits within the, on the elevation.
But I mean, are there windows there that sort of prevent you from realistically bringing that roof below, or the sign below?
The height of the overall sign or the pent itself?
Either one.
I'm sorry?
Either one.
There are windows established. If you look at this drawing, this is the new side entrance showing the door. There's a clear story.
What drawing is that? What number is that one?
This one.
Or we don't have that in the packet either?
It's actually on the overall sheet,
On A8,
A8.
at the top part of A8 is the broad view
Okay.
of the entire that's facade, south facade of the building, and this is a detail that is not in your packet.
Okay.
So even if you wanted to bring it down, forgetting about tractor-trailer concerns, you'd have an architectural issue anyway,
Oh,
right?
definitely
Yeah,
would be.
okay, thanks.
Just as a qualification, or clarification rather, the original application has a different A9B than the one that's attached to the materials that we just received. Is this, because this one shows the blade sign only 11 feet off the ground. Has there been a shift?
Yes. Thank you for calling that out, John. The shift is a redesign to make sure that it accommodates any mode of traffic that could travel on there. So, as Greg mentioned, a semi-truck could come back and it would still clear it. Pennsylvania state maximum is 13'6", and we redesigned this to be 13'9", up from 11.
Safe to say that we should be looking at for the application in toto, the packet dated October 20.
I was going to say, what do you want to call that, John?
Well, they're all labeled. The question is, there's 2 different packets. I assume that we should toss the September 15 packet and enter your exhibits as labeled per the October 20th packet.
Please.
Okay, so the ones we got in September.
Okay, the only thing I want to keep from the September packet will be the cover sheet, the appeal sheet. The drawings and everything else.
Actually, they're in the, they're A1A of the October sheet.
Okay, so we're going to get rid of everything dated
Yeah,
September.
The packet that we got in September is out. I have to say, a drawing like the original A9B was a little easier on the blade sign than what we have here.
I have a few questions. Are you finished with the materials, John?
Yes.
Okay. I'd like to ask you a few questions. Are all of the spaces in the building accessed through the front entrances? Could you walk through those doors and get to all your spaces?
No, you couldn't. It depends on, do you mean the historic front doors on the east facade, or do you mean?
The ones facing North Wayne Avenue. Does that provide access to all the rental spaces in the building?
No, it doesn't.
So some spaces are only accessible through the side door?
Correct.
And the handicap accessibility.
Well, I understand.
Can't hear you. Can't hear you.
You have to use your mic.
Is it not on?
Yeah, is the button on? Is it button up
Yeah,
and
yeah,
down?
it's on now. You just have to hold it closer. People at home are watching us also on TV, and they have to hear you. So,
No, from the front facade, only the storefronts in the lower level are accessible from the front. From the side elevation, all of the potential tenants have
So the side
accessibility.
entrance is really the main entrance of
It's
the
the
building?
main entrance of the building.
Okay.
Because it provides the accessibility.
That explains a lot, yeah, okay. And the other questions I have to do with our projecting sign section of the Wayne Business Overlay District of the ordinance. There are a number of things there. Is this sign going to be illuminated?
Yes, it is.
You haven't asked for a variance to do that. That's prohibited under 280-5315 M. It specifically says signs shall not be illuminated, but you haven't asked for a variance for that.
Is that specific to projecting signs, or is
This
that any
whole section
sign?
is projecting signs, which this would fit under that definition in this section of the code. The other thing was, there's a section in here that says that it's projecting signs shall be pinned away from the building wall at least 2 inches and no more than 6 inches. Do we comply with that here?
Yes, we do.
Good, okay. And then the materials, what are the materials that we're using?
The sign itself, if you could look it on, which drawing is that in their packet?
812.
The letters themselves are matte black, halo lit. They're potentially would be lit from the back on an aluminum finish metallic.
What are the letters made of?
They are plastic, like cast, but like a cast letter.
See, under subsection J, it specifically prohibits the use of plastic and vinyl or highly reflective materials.
So
You're not allowed.
they're matte black.
But it's plastic. It says you can't have a plastic or vinyl material in a projecting sign in this district. Again, you haven't asked for a variance, so I mean, even if we wanted to grant you that one, we really can't do that tonight.
If they were a metal letter, would that be acceptable?
Well, it wouldn't violate this as long as it weren't a highly reflective material.
So a matte black metal letter would
Would
pass.
not violate this section,
Correct.
I think, but the question is whether you need other variances that you haven't requested. So that we
Yeah, the
can
reason
entertain.
we can't, what's been advertised is only the height of the respective heights of these two signs. Pennsylvania law, as Mr. Cutler is alluding to, requires that you advertise all the relief. And if we were to grant you more relief than is advertised, the approvals could be challenged indefinitely because they were, done out of our authority. We have to, if you ask for 2 variances and you need 4, we can't, if we give you the other 2 you haven't asked for, the approval is held to be ultra vires, outside authority, and can be challenged indefinitely. So that's why we have to make sure that we're advertising this properly. We've not advertised an illuminated sign, which requires an additional relief, and as for the vinyl, as Mr. Cutler says, that's, you'd need a variance from that. I mean, the question is, do you want to continue and re-advertise to get the proper relief in that you want, because we can't proceed to give you relief that hasn't been advertised.
I think you have 2 choices here. Okay. We can only vote on whether to grant you or not grant you the variances that you requested, which is the height from grade and the projection sign. Okay, the height there. You can't make it out of the materials that you're not allowed to make it out of, which you thought it was going to be plastic. You can't do that, okay, because you didn't ask for that. So we can't grant that. And you can't illuminate it. Okay, so you can either go with, what you requested, and we only deal with the height thing, and you come back, or you can ask for a continuance if we grant it to you, and do the whole thing and ask for whatever you need to think. But if you do it that way, I think you need to really look at the code and come back with a plan that you want that's within the code, and ask for those variances that you need to ask for. Because it has, as Mr. Ryan said, it has to be advertised. We can't, say, oh, well, you forgot that. Well, we'll just give you that. It doesn't, unfortunately, we can't do that, and that would not be fair to ask us to do that.
The public's got to be put on notice as to the extent of what you're asking for. Now, if you asked for 3 variances and decided you didn't need 2 of them, that's okay because you asked for 3 and then you took your application back. But you're pushing your application forward, out beyond what you have. Frankly, I think going through the code, we're supposed to give you the minimum relief, assuming there's a hardship. And instead of coming 2 stages, well, this is what we want for our variances. Oops, we forgot we need 2 more things. Is not particularly a presentation that says you've thought through what you want and come to us with the minimum relief. And again, to the extent you can conform to these provisions, like avoiding the vinyl, it seems to me you should give serious consideration to that. But if you want the illuminated sign, and you feel that's important, that's not something that can be voted on tonight.
It sounds like we're creating a complication, but actually we're saving you from one. Because if we gave you the variances you asked for today and you went in for a permit to put up the signs, technically it wouldn't be granted.
You wouldn't get.
And then it sent you back here, so we'd be seeing you many months from now.
The
So
other
we may as
piece
well
of
do
it is if there's an appeal period of 30 days after which it can't be challenged. If we grant you a variance that hasn't been published, it's held to be ultra vires, and under the Luke v. Cataldi case from the Supreme Court, theoretically could be challenged forever. So somebody could come by 10 years ago and say, yank the sign down, and it wasn't properly published. And that might work. In other words, you don't want an approval that can be challenged forever.
And we have some folks in this town that might just do that.
All towns have them, not just Radnor.
Well, that's all helpful. Thank you. And I want to say that we weren't aware of those other parts of the noncompliance. Just crossed my mind that it might be perceived that we were trying to slip those in. That wasn't the case.
No, because
So
you mean if you did try and put them in and you went to get the permit, they won't give you the permit.
Yeah.
Because you would have to
I understand.
technically list all that stuff, that it's going to be illuminated, it's going to be made out of plastic, and our codes department would say, oh, wait a minute, you have to go back to zoning, and, this might be 5 months from now, so.
We're just learning how to work the mics, though.
Yeah, that's right. So what would you like to do?
I'd like to appeal for the variance on the wall sign for the front
The front?
and ask for a continuance for the blade sign.
Can we split
Is
that
that
up like
possible?
I guess we could do that. I think it would be better, frankly, to do it all at once. But I don't see a legal impediment to that. I think, I would get the whole package done and bring it all in together.
Does it help your construction schedule to get the one approved first?
I don't have a preference. I have to come back anyway, so.
I mean, if
For the
there's no
signs.
compelling reason, I think it would be better to advertise everything and do it
Yeah,
all
I
at
think you'd be
once.
better off, then someone's thinking we're trying to pull a fast one on.
Okay.
And if you got to come back, I personally don't perceive the front sign as an issue. It's more the side sign that's an issue, making sure that it conforms as best, and we give you the least amount of relief that you need.
Okay.
John, would they be required to file a whole new application, or can they amend this one and just re-advertise?
Well, I think they can amend this one as long as we re-advertise.
So what we have to do is amend this to add the additional variance requests, whichever ones you think you're going to need when you review the code, and then they'll have to go through the re-advertising.
And I think you ask for as much as you think you need. You can always go back, as Mr. Ryan had mentioned before. If you ask for 5 and you wind up with 3 that you need, it's better to do that than where you are tonight, where you asked for 2 and you need 4.
But also, by the same token, if you can do without something, like you could get around the plastic, for example,
Because you'll have to show a hardship as to why you can comply in order to
black
get that
metal as
variance.
opposed to plastic, black vinyl.
And how you're going to show a hardship that you have to use plastic. I mean, maybe you can, but it eludes me, unless you have a weight issue or something on it.
Okay? Would you
Thank
like
you.
a continuance?
Please.
Mr. Falcone, the question, they're going to have to amend the application, and then it's got to be re-advertised. What is the deadline for getting it re-advertised? I mean, do you want to continue, the question is, do you want to continue to November or December? Do you need the time? Because advertising is
So
what-
when do they have to have it in by to get it advertised for next month?
Actually, it was Wednesday. Was the
So it
cutoff.
has to be till
Yeah,
December.
this past, yesterday was the cutoff for
Okay.
November.
So you're going to be looking, and that's really probably better for you. This way you're not going to, Nothing will slip through the cracks.
You won't rush, you can look through the code and really think about it, and then still have plenty of time.
What's your construction time? What's your,
The core construction of the shell is complete.
okay, so just the signs are,
So there's a retail tenant now up there on the first floor.
yeah, but that
January
sign wouldn't
1st, there'll
affect
be an
him.
office tenant on
Yeah,
the
that
second floor.
You know, that's not gonna, it's not an index sign or a,
Yeah.
so it's just a marker, and everybody knows that building anyhow, so.
Yep.
I don't think that, we're looking at the alley. You know, I mean, it's not like it's,
Yeah, if we could do November, that'd be preferable. If we
I
could
don't
do
think we can,
December,
because
then
the deadline for advertising, the statute has, and our code has a minimum schedule in advance of a hearing for everything to be in, so it can be properly advertised, and under our code, we've just missed that date.
Okay. Well, then we'd like a continuance to December, please.
okay,
And you'll give us an extension of time to, hear and commence a decision after that.
yes, to say yes.
Yes.
Any other questions? Anyone have a,
I guess I just reiterate, I mean, make sure you come with a hardship next time, and especially with the projecting sign, since the code says 4 square feet and you're at 40. We'd like to understand the rationale behind the 40 and why it's absolutely necessary.
all right, thank you. Yeah, you can leave them out, because the next person is going to need them. All right, thank you very much. As I had mentioned before, Appeal 2863 has been continued. Appeal 2864, the applicant Paul Bloomfield, property located at 405-407 East Lancaster Avenue, Wayne, Pennsylvania, and zoned R5. Both properties are existing non-conforming with respect to use and coverage limitations. Applicant seeks relief from Section 280-35A side yard setbacks, building and impervious limits. Applicant also seeks relief from Section 280-101A2 and 280-101B1 with regard to enlarging the non-conforming conditions. You're the last one. You're the last one.
I mean, I have a question to start. Mr. Bloomfield, what is your interest in the property? Are you an owner, a buyer, a tenant?
I'm an architect and working for
So you are not, you don't have any possessory or ownership interest in either property?
That's correct.
Mr. Chairman, I would move that we can't hear this application, because the man who's applied for the relief has no legal or equitable interest in the property. He's a professional consultant.
Acting as an agent to Mr. Emerson and
But I mean, we can only grant relief to the applicant, and you have no interest. We can't grant it to someone who has no interest in the property. See, sometimes people come in as a buyer and they have the agreement of sale that shows that they have an equitable interest. Sometimes they're the owner and they have a deed. Sometimes they're a tenant and they have a lease that permits them to seek this relief.
Or
But
they
they
have
have to
power
have
of
an interest
attorney
in the
from
real
the-
estate.
or
We
power of
talked
attorney.
about
Well, that would
power
give them
of
the power to act like to sign things, but not to apply for relief.
Okay.
They can't apply for relief in someone else's name.
we do in fact have a power of attorney for Patrick Gibbons to speak on behalf of.
I mean, that might enable you to be the representative. But I'm concerned whether that, I mean, how can we grant relief to someone who has no interest in the property?
Well, if he has somebody who's here to bind the record owner for appropriate power of attorney, then that person.
But who will we grant relief to, John?
Grant it to the
Mr. Emerson?
property. Grant it to the property.
You can grant it to the property in rem, not to an applicant? I mean, don't you
Well, the
have to
applicant
grant relief to the applicant?
Yeah.
The agent has a proper power. There's some suggestion that there's a power, we haven't seen it, so we don't know what kind of powers are granted, but if the property owner is acting through a duly appointed agent
Right.
with
so
the
in other
power
words,
to bind.
That would enable him to apply on behalf of his client.
Correct.
But not on behalf of himself, which is what he's done.
Well, he can join in the application and make it his own.
Has it been advertised as the application of the owner?
No, it's not, it's silent as to either way. I don't see that as a.
Do we have a copy of the advertisement here? This is just a
Isn't
blurb.
this the advertisement?
This is just a blurb. Isn't there an actual
No,
advertisement?
I think this is what goes in the paper, right? Yep, this is what goes in the paper. This is the advertisement. This
It says the applicant, Paul Bloomfield. So, I mean, people would think that this is not the property of Mr. Emerson.
It's a risk for the property.
I've seen it done this way, no. I
Okay.
agree it would have been better the other way. We do have to have a power, though, from the owner before we can proceed. If that's-
Before he filed the application, he had to have done it with authority.
Well, I think they could be ratified after the fact. It would be better if the owner had joined in it, but I've seen it
Okay.
done this way. But
I've
we
done it
can't-
myself this way in this township before. I do have a copy of the application. It lists the property owner. It lists myself as the applicant, his agent, but it lists Scott Emerson as the property owner.
Do we have a deed, by the way, for 407?
Yes, we do.
Because
You-
there's
that
only
was-
a
you didn't
deed for
have it in the
405.
packet.
No,
but,
I was.
We have the power of
I got it
attorney.
today, and I have the power of attorney, and I have the deed.
Sir, I need your name.
My name is Patrick Gibbons.
Why don't we swear them in? Why don't we do that now before we go any further, please? Thank you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
And state your names one at a time.
Patrick Gibbons, Gibbons.
Paul Bloomfield. So we do have that power of attorney and a copy of that deed. And I have one more drawing to provide to everybody as well.
Could I?
Should I give the deed in?
Yeah, they should be given to me. Just 1 second, I need to do one thing from the last hearing.
Would Mr. Cutler would like to see the application as it was
And then let me
submitted?
see the deed.
Oh, you do have a copy.
407.
Yeah, you needed 407. This is,
That's 407.
okay.
The application just says name of applicant, Paul Bloomfield.
Yeah, I don't.
It does indicate that the owner is Scott Emerson of Emerson Group.
Oh, right, I understand from the deed as well who the owner of the property is, but the application was not made in that name. That's all I'm saying. It sounds like a technicality. You're really at risk if you go forward, because if it is a problem and anyone attacks this, you'll have to deal with it. I mean, our solicitors advised us that we can cure this problem, so we'll proceed. You're throwing the dice.
Is
I'm
Patrick
not.
Gibbons, you're Patrick Gibbons, okay.
Could we just give me 1 quick second to look at the materials and, I have the deed.
I also have a revised drawing I'd like to give out.
Yeah. Just one step at a, if we just do one one slow step at a time. Okay, I'm checking the deeds.
Have copies of the deed for everybody?
This one piece says,
He has one for 405 that we
one's-
all got, and then 407 has been brought in.
this one piece says Scott Emerson, owner will be available to answer any questions. Is Scott Emerson here?
I have the power of attorney.
Okay.
Okay, I haven't gotten to that yet. I'm looking at the deeds.
Yeah, I got the power of attorney today.
Wait, the second deed you handed up was 405, was 407 we were missing, right?
I have them both here.
Yeah, the guy 407?
I thought I gave you 407.
You gave me 405. Okay. Yeah, there we go.
Sorry. You can keep that. It's just an extra
Okay,
copy.
an extra
if you need
copy
it.
of the
Yeah.
deed.
You know, we had, this is a thought, Noah, you can listen, and Brad and Jim, and Pete. We had the same problem, almost the same appeal last month. And the way they solved the problem was, they combined both lots. And that got rid of your side yards, because now it's just one large lot that 2 buildings are connected. the other problem they had and they solved also was the impervious. You're going to have to solve that problem too, in my opinion. And by combining the two lots, you have less of a problem to solve than leaving it the way it is. Because in the one lot, you're increasing it by 4%?
6%, I think.
Was it 6%?
But
Maybe it's 4% because you get 2% from the other lot.
Right.
So it's an overall 4% increase in impervious.
No, if they combine them, they're short 4% on the other lot, so it
Right.
would be an increase of 2.
Right. Combining them, it kind of reduces to 1 or something like that, which you can probably figure out, get rid of something, the sheds or something to get you in code. And then you wouldn't really necessarily have an issue with side yards because you'll combine both lots.
You may not need any relief at all.
That's right. You may not need any relief.
Are
We
I
would still
haven't
be
seen the
facing
deed. Are
the
they
existing
titled exactly the same,
nonconformity.
Joe?
Yes, I believe they are.
The other application had the additional problem that they were titled in different names.
Right, and they changed
decided
it.
that they
Yep.
would convey.
Right.
But
Well,
I haven't seen
But
the
then
other
you'd be in
deed.
a 280-101, not increasing the existing nonconformity.
Emerson.
Well, as long as the
Right, we'd still be
grantors or the
requesting that
grantees are
relief.
the same,
You
that's
would,
fine.
you,
Same.
I can't.
we're all
Fine.
talking at once, sorry.
Okay, one at a time.
If you combine the two lots, you have no more side yard setback problem because you've eliminated that line. You would still have, it appears, about a 2% increase as proposed on the impervious, but
It's actually a decrease,
well, it's an increase on one, a decrease on the other, a net increase of 2%.
net decrease,
I'm talking about on both.
yes. If you look at the bottom there, it gives you the aggregate impervious totals on the lower left. So on 405, we're actually reducing the impervious by 500 square feet, and on 407, we would be increasing it. So the net is actually reducing by
Yeah, but
250.
that's only if they're combined.
I
Right?
understand.
So if they're not combined, it's an increase.
Right,
Okay.
as it is right now, 407 is asking for an
Right.
So
increase.
if you
and
eliminate the
405
lot
is a
line,
decrease.
you don't need to come here. You just need to get a building permit.
The other case we had,
Would we
they
not
did,
still be facing, I'm sorry, the existing nonconformity being expanded? This is a R5 zone with a commercial use. And we would be,
Oh, you're non-conforming as to use,
yes,
but you're not seeking a
Yes, we are.
variance as to use.
we are requesting relief from that code that restricts expansion of an existing nonconformity as to use.
It says here you're seeking relief from 28035A, side yard, building, and impervious, and also seeks relief from section
Oh,
28101A2
yeah.
and 28101B1.
Yeah, I've lost my
With
copy
regard,
of that. but-
so you didn't even ask for it.
No,
No, those two refer to
A1
those
and-
existing
Oh, it says
nonconforming uses.
regarding enlarging nonconformity
yeah,
conditions.
they asked for it.
Okay.
Okay.
So, but with the one that we granted last time, the only relief we ended up giving them, because they had combined the lots, was to confirm, they had two variances for the two properties with different uses, stated uses, which actually were the same thing. And our decision was to make it clear that they could use both as a spa, because that's what the two buildings were done. So it was really a cleanup the record, but they didn't need dimensional relief for straddling a property line because they agreed to merge it. And one of the conditions of that approval is that they do have to merge the two and get whatever subdivision approval, if any, that they need, and then file a deed consolidating the two into one parcel. So that was, you know, that removed the big, what I see as the biggest concern in that appeal was the agreement to merge the two lots. And the approval we gave really was to clean up the record, to make it clear that, you know, the wording on one of the buildings was like a skin care or something, and the other was spa, and they're really the same things. We just said everything's a spa.
Well, this property, we do have the same use on both
Yeah.
405 and 407. There are a couple of other differences, though, that might suggest a different response here to this site. And if I may, just describe a little bit about our thoughts as to why we'd rather not go the route that you're suggesting. First of all, I'd like to back up a little bit. When this was first conceived, I spoke to Ray Daly about how to approach this problem, and it was at his suggestion, actually, that he suggested that we request the side yard setback relief. But what we have here is two separate buildings that have really a different character as well, and kind of the second building at 405 has been recently purchased by the company, and they've actually spent quite a lot of money renovating and so forth. And it's actually a very stately facade, and what we'd like to do is not compete with that, but have a connection between these two buildings that doesn't seek to make them into one building. And what we're actually conceiving is an open breezeway here. So not even necessarily an enclosed space. We have a connecting roof element between these two buildings, but it's not an effort to make these into one building. The two buildings themselves have, by their nature, a lot of differences that would make it very difficult to combine them into one building. They have a different appearance and a different style, but also they're built at different elevations and at different angles to each other and so on. So a serious connection and a serious effort to make this into one property and one building long-term seems to be not the appropriate solution here. I think if you look at the photographs and the other elevations, you see these are really clearly two separate buildings. And ultimately, I think the company would certainly like to have at least the option of making business decisions that would let them separate this again into two properties by removing this connecting element. We see this really as kind of following the historic guidelines where you have an ability to make an addition to a property and remove that without having an impact on that original property.
Excuse me, is this breezeway going to physically connect to each building? Right?
It will touch each building, yes. But
And for instance, just as an exploratory here, if we conditioned the granting of the approval of this variance on the fact that you could never separately mortgage or convey unless you physically removed this entire connection.
Yes.
You would not mortgage them separately, lease them separately, convey them separately. That would be an acceptable way of
I
proceeding?
believe so. That's why we have Mr. Gibbons here to make the
Yeah, I just want to make sure I understand your question. Could you ask that again?
Again, I'm just thinking here. I'm not suggesting that we would go that way, but if you decided not to merge the lots because you wanted the future flexibility,
Right.
and you talked about removing this, you would be willing to condition any kind of severance of the title, whether you're mortgaging them separately, because that could result in a foreclosure and separate the titles, or selling them, anything like that. You would not do that as a condition of the variance until you removed this physical connection.
Absolutely, we'd
It
be
would be
fine with
gone.
that. Yes.
Okay, well,
Understood.
that's good to know.
Yeah, we'd be fine with that, because, you know, we're using it for the single business use, so if we ever sell it, we will not have the use of going back and forth. So we would be fine with that.
So you realize that means if you were ever going to mortgage just one property and not the other, you'd have to remove this. That's part of what I said. You really have to understand what I'm saying.
Just talking about a conveyance where you're selling one property. He's talking about being able to refinance a property and so on.
Because if you mortgage one property without the other and down the road you were to default.
No, I
then
don't think we can do that. I don't think that, we've had this discussion before about putting conditions on a property where they can't sell it or do something with the property.
Oh, no, we're not saying that. We're just saying before they would do that, they would lose the variance. They would have to disconnect these buildings.
Yeah, I understand, but.
We're not saying they can't sell. They can
Yeah,
sell.
no, what I mean is I guess I didn't finish the sentence, that they can't sell or do something with the property without doing, they can't do B unless they do A first. Whatever A is, all right, that would have to be into the deed.
But we can say that would violate the variance, terminate the variance, and therefore the property would become in violation. That we can
Yeah,
do.
but 5 years from now,
If they were to sell one without the other and didn't disconnect this, they would lose the variance and the property would be in violation.
Yeah, I would have a hard time with that one.
Okay.
That's just my that's my personal.
Well, I'm not even suggesting we go that
Right.
way. I wanted to know if that was acceptable to them
Right,
as something
okay.
to think
Yeah.
about in this whole mishmash.
As far as the use, it would be acceptable, but financially, the business may require that you refinance the property for whatever reason. Scott, as the owner, may have a need to do that and then take that money and reinvest it into the business. So
Well, we weren't saying you couldn't refinance, just you couldn't sever them. You couldn't mortgage one property and not the other, or mortgage them to under separate mortgages. That's what I'm saying. Now, if he wants to finance the whole thing, as long as it's done as one thing, that's
But they're already financed separately.
well, then that's
As
an
is.
issue.
One was bought
Then that's
10 years
then
ago.
that's an issue. See, because that could result in a severance, and that's one of the reasons why we had a problem with the application that was referred to before, the prior case, where they were held in different names, and they were separate titles, and they wanted to connect the buildings similarly to this, not exactly the
They're
same.
two different mortgages right now.
And that's something we need to think about.
What's there now? What are the properties being used for now?
For the Emerson Group's business, it's a sales and marketing company. So we do all of our business throughout the United
And
States.
what are you going to do there after you connect them? Same thing?
Same thing, it's just office use.
Yeah, you
Are
have
the
a number of
buildings
employees.
conforming or non-conforming, the actual structures? Are they conforming structures or non-conforming structures?
They're conforming with respect to building area, but not impervious area, but the buildings themselves are conforming with setbacks and so forth, yes.
The structures are okay, they are conforming. So you don't need a variance from this, for expanding a non-conforming building. You're talking about expanding buildings that are used for non-conforming use?
Correct, yes.
Okay. So really 101B1 is not involved, because B1 deals with a non-conforming building.
I lost my sheet. The other one is the one that refers to the non-conforming
It's
use.
101A, 1 and 2 that you're really talking about. Well, you're only talking about 1, it's A2. It's A2. You're taking a non-conforming use of a building, and you want to extend or enlarge. And the question is, can you do that, or are you increasing the non-conformity?
But if it were one building, that wouldn't be an issue, right? Noah? If they made it one property, that wouldn't be an issue, would it?
I think it's the same issue. It's still the same use.
Right.
Still non-conforming use. So it's the same issue. We may deal with it differently. But
Yeah, we would deal with it differently.
I want to read this section so I make sure I'm considering all the provisions. It says the non-conforming use of a building shall not be extended or enlarged. They aren't extending or enlarging a non-conforming use. And a non-conforming building shall not be extended or structurally altered except insofar, well, this is not a non-conforming building. This further section, unless zoning hearing board shall, as a special exception, authorize extension of a non-conforming use. You're not going to conduct your office use in this addition, right? This is just a breezeway.
No, it's a breezeway, just to keep everyone out of the rain and walking back and forth, basically.
You're suggesting that the expansion is not an expansion of the use.
You're not going to make that use of this
Correct.
breezeway. I'm not so sure they even need
Well, that's what I said, I don't think they do.
a variance under 101A2 on these facts. On these
Special
facts.
exception.
Okay.
I think it may be an expansion of a, I mean, that's at least arguable.
Yeah, a special exception would be a lot easier.
Yeah, but I think without merging the properties, you're in variance land. And I think if you look at the definition of a building, this is part of
On the dimensional question.
the dimensional question.
Clearly on the dimensional, I think they're talking about use right now.
I was just taking a look at the definition of building. It's a structure having enclosing walls and a roof. Well, this is part of the structure. Even if the main building is off, it's a structure
Yeah.
that connects the two. I think it's part. It does conceptually in terms of vernacularly rather. It might not seem that they're part of combining the two buildings into one, but for purposes of the code, I think it does, and I think it results in a building straddling the line.
Oh, it does, clearly. I mean,
So, but does that
you're creating visual, you're keeping visual
does that
separation, but
count
they
as
are
increasing the non-conforming use, expanding the non-conforming use? I mean, it adds square footage to the building, so I think the answer is yes.
Yeah, I agree.
We're not actually necessarily enclosing these walls. We are putting up a roof
That's
structure.
part of the structure, though. You're connecting, once you connect them above ground, and that's on the land, which is the key word here. So it's above ground, and you're connecting.
Remember, our code defines structure and building differently. So I guess we need to look at that.
Well, it says a structure having enclosing walls and a roof. I don't think it says anything about that located on the land. I don't think it says that once you get outside the roof, the enclosing walls and the roof, any part of the structure is no longer part of the building.
See, building is defined as any structure having enclosed walls and roof permanently located on the land.
Yeah. Yeah, a deck is
Are
part
there
of it.
enclosing walls on this breezeway?
No.
No, this is just an open breezeway.
Yeah, but there's a physical attachment from building to building.
It's a structure, but it's not a building. What
Well,
they're- what they're
once
proposing.
It's a structure that's an expansion
on
of the
either
other
side,
buildings.
Yeah. It's part
that's
of
like
the-
saying the portico on my house is not a building. Of course it is. It's part of my house, right? But technically, if it was freestanding, it'd be a structure. But it's not because it's affixed.
Or an above-ground deck.
That's just my opinion, at least.
I think it's my opinion.
But is that the use of a building, non-conforming use of a building?
Yeah, because you're expanding the building. I think both the use and then for dimensional purposes, the fact that it's a building itself are in play here.
Okay, so, but you're not willing to merge them, right? That's not something you're willing to do. So you may as well put on the rest of your case and we'll vote. I don't know what else. There's nothing else to discuss. We're beating a dead horse.
That's right.
It's certainly not our preference, and
Okay, and the other thing is, at least I haven't heard, and maybe you haven't gotten to it yet. I haven't heard if you decide if your opinion is that you're not going to try and merge the two properties into one. Okay. We only give variances and special exceptions of relief from zoning based on hardships, and I have yet not heard any hardship. Why you need to do this?
And it's a compelling need, not just that it will be desirable or useful. It's, you know, it's a
Or
much
monetarily beneficial to you. That's not a hardship for us.
Right. The reason why we're doing this is we have a national company, and we bring in, high-level executives from all over the country, from the executives from Merck, from Novartis, and we're trudging them through the rain, and then, when it's raining, you're going through the mud to get back and forth.
Okay, not that.
Merck would understand. They have about 50 buildings on their West Point campus, and they have to trudge through the rain to get from one to the
You have to
other.
understand, hardship means our lot's like a triangle, so therefore we can't, we're going to encroach because as you move it up, or our lot is really skinny, or things like that. Things that are beyond your control, nor has an effect on monetary gain for you. That's not, to us, that's not a hardship. Hardship is the way the lot's laid out, different things that are beyond your control. And I haven't seen or heard one yet.
Well,
Why
And
you
keep in
wanna-
mind that if you merge these lots, you don't have any of these problems.
I
But
understand.
they can't. They're separately mortgaged. So basically,
But that's,
they
but that's not a
that's-
problem.
that's-
Just a company
that's a
buys them
solvable
and
problem.
then refinances them and puts them as one. That's not an issue. I mean, it's,
well, I mean, but it is a practical issue. I mean, they can't.
But
can't.
that's a
We're
business
telling
problem
them that
they
would
can
change
solve.
our view of the case, but they basically can't. Beating a dead horse. But
rather than beating a dead horse, can I get a little better understanding on the question of the expansion of the use? Is that something we're still required to get a variance for?
It's a special exception.
It would be a special exception.
and special exceptions are easier than variances. And use variances are the most difficult.
But dimensional.
you don't need a hardship for a special exception.
Right.
You need a hardship for a
But you need a
variance.
hardship for a variance.
And while this is a dimensional variances, and the cases say that the hardship is a little less, it's not much less.
Right.
It's still a very severe showing, and there are a stack of cases that say that the fact that it's a little bit less doesn't make dimensional requirements sort of things that you comply with if they're convenient, but otherwise relief should be granted, just not what the law says.
Well, obviously, it's understood that this company made a decision to purchase the adjacent property. They brought that on themselves. But the fact is that these two properties do have a relationship to each other that they're just trying to find a way to make that work. So the fact that we've got these two different structures that can really only be accessed from a couple of points on these sides kind of limits the options here as to how these two buildings can possibly be connected. The hardship, so to speak, that comes from that is really just a fact that the relief from the side yard setbacks has to be complete to make this connection. Obviously, you've got to reach from one building to the other. So, we're asking for the minimum in terms of what relief that would suggest. But the hardship in terms of the company, we understand that's a business problem that's not related to the property itself. These properties obviously existed long before the company started to take control of them, and it's just in doing that they've encountered these difficulties along the way, and they're really just trying to find a way through this problem.
I think we're inferring that before the purchase of the second building was made, this issue was envisioned. Yet the purchase was not conditioned upon obtaining variance relief and approval to build this.
And I don't know to what level.
So the decision was made to live with it either way, and then figure out it would be better if we could do this. So that doesn't sound like a hardship. It sounds like you're
It would
trying to
be
make
nice.
things better, but you don't
Correct.
necessarily have a hardship.
That's correct. I think that's accurate.
And how about the use what's the other one, the use? The use variance?
If he doesn't do
Expansion
anything,
of the use
Well,
is special.
no, what I'm thinking is, here's my thought process, is if we vote on both of them, and maybe the board votes that we give them the use thing, but we deny the other one, then they might say, well, we got the use, let's go merge the properties instead of having to come.
but in
Can we
the,
do that?
I don't think so, because in the absence of the dimensional, they don't expand the use.
Okay.
Am I right about that?
That makes sense. I mean, it seems to me that you know, just, I don't have a voice on the board, but it seems to me that you may want to go back to Mr. Emerson. And, you know, you've heard, I'm hearing certainly some real resistance to, you know, and concerns about granting a variance over two separate properties that already are separately mortgaged. So if one or the other is foreclosed upon, the severance issue is very real. And, you know, concerns that the hardship is not there. And maybe Mr. Emerson would want to think about agreeing to merge the lot and then bring it back just for the expansion of the non-conforming use. But maybe that's something that ought to be brought up, you know, take back to your principal and see if he wants to do that and continue it, and you can come back. If you merge, you don't have to re-advertise in this case, because if you agree to merge the lot, remember we talked earlier, if you're asking for, you ask for two variances and need four, that's a problem. But if you ask for four and only need two of them, that's okay, and that would be the second situation.
We also have to number these, John.
Yeah, we have to go and enter your exhibits into the record.
So let's only do that.
Let's see.
Why don't we call it the zoning hearing application A1? Okay,
Happened like that.
we'll call the,
Just a second. I got it.
I don't have a copy of the power of attorney.
Okay, let's, the power of attorney I have, and it looks okay.
Okay.
We can make that A2.
Make that A2. You want to, let me put that in the record,
Okay.
in the folder.
Does it have ratification language, or is it made as of an earlier date? Because it has to have effect as of when the application was made.
And it says it's executed as of October 20, but I don't think that keeps them from ratifying the application that was filed.
No, not if it says it's ratifying it.
It actually says which I have filed before the Radnor Township Zoning Hearing Board. I mean, it's not absolutely perfect, but I think it would work for our purposes.
That's how you're advising us, so be it.
So here's the power will be A2.
You have become awful mellow.
What happened? Send that up to.
Did you have a drink before you came tonight?
Okay, let's make the deed. I was going to say we have two different deeds. How about the 405 deed is A3?
Is that the one I have?
Yeah, and then I've got the.
All right, so 405 is A3.
Yeah, and 40. I'll give you the 407 deed is A4.
Okay, and also I have a letter. I have a letter. It's not signed, so I don't know.
That's from Bloomfield's firm.
That from the Emerson Group. Okay, I have a letter from Mr. and we'll call that one A5. Okay. Are there any other exhibits you want to put up?
You have the drawings, and some of those are numbered A1, A2, et cetera, but
Okay, I only have one. Could you give us more than one?
Yeah, there are a bunch of
Okay,
foldy
mine.
things
All right,
from
these
the
are mine.
application of
Okay.
photos.
yes, there was a package that had photos and plans and so forth.
All right, so I have this group of drawings. We're going to do the drawings A6, A7, A8, A9, and we'll do the pictures as A10. I think that's all of it.
Well, they had hold on a second. He said.
Mr. Balcone, could you tell me which of those drawings you
Yeah,
assigned which?
okay.
Okay, we also
exhibit
got
numbers?
an additional drawing that was.
I did that one. I did that one as A6.
Oh, okay,
So
then
the
what?
additional drawing is A6, the one you handed up tonight, which is S2.
Yes?
Okay, does
All
that
right.
mean we're getting rid of the one that was in our packet? Because in terms of drawings in our packet, I have, including the photographs, I've got 4.
You don't need to get rid of anything.
Right.
The original one was the existing plan.
SP I marked A7,
Which one is, okay, this?
SP.
That's
It's
A-
marked SP at the top,
Okay, that's A7.
right? The one that's marked A1 is A8.
Okay, where's the A, okay, this, okay, A8,
The one marked A2 is A9,
yeah. And the photos are A10?
and the photos marked PH is A10.
Okay,
Is
and
that all of
then
them?
The
Yes.
S2 is A6.
Yeah, S2.
Okay.
So we have 10 exhibits, correct?
Yes.
Okay. Now, kind of help me here, John, so I understand, so they understand as well. If we vote on this tonight and we turn it down, and they come back and they say, we're going to combine the properties, the only thing relief we need is the variance, the
special
non-conforming
exception?
increase variance,
The
correct?
Special exception.
The special, I'm sorry, special exception for
Yes.
the non-conforming increase, right? For the use.
Yeah, because based on their zoning
Okay,
table, I don't
understand.
see them getting rid of any of the other.
Is that right, Noah? You understand,
Passing any
right?
of the other limits.
We would not need to revisit the impervious
I'm just,
because our
I
net
mean,
is
it's like, do you
reduced.
understand that the way it to be?
I understand that's the way we've decided to view it, yes,
Okay.
as a board.
S2 is A6. Do you have anything else? Did you-
I just want to summarize what I think I
Yep,
heard.
okay.
So I'm going to go back to Mr. Emerson and say.
Do you want to ask for a continuance?
You think so? Yes.
You're suggesting that the correct way to do this is to get our decision made on
What you wish
combining
to
the lot,
do.
and then ask for the special exception.
Yeah.
Yes.
You're already advertised for the variance and the special exception, so you wouldn't have to advertise. But if you could make the variance go away by agreeing to combine the lots, which is something Mr. Emerson would have to address, assuming you could do that, then you can come back to us saying, well, we really only need the special exception now because we no longer need the variance because we're going to merge the lots.
And you'd be on for November because you've already been advertised.
Yeah.
Okay.
The
What
case
if
before
one
you
of the
had
buildings
more
is-
advertising that needed to be done, which is why they have to go to December. But you could be on in November because this
You're
has
not
been
adding
properly
anything.
advertised.
And we can't vote on that question now because otherwise we don't have an expansion
Right.
that we can talk about.
It's moot.
Right.
The special
If you don't
exception
get
is
the
moot if you don't get the
have the
variance.
dimensional, then there's no expansion of the use.
And one last question. What if one of the buildings is owned free and clear? That makes just everything easier.
No,
it
no,
doesn't- it's, the issue
you
here
should-
is
wow.
combining the two properties. See, I don't see them being two different mortgages as an issue. It's more,
No, it's an issue.
well, no, you just have to refinance. You just.
Well, that's the big
Oh, yeah,
issue,
well,
refinance.
yes, you're right.
They'd either have to
You
spread
could-
their mortgage over the whole recombined
Yep,
property.
yes.
Which means they now have the whole thing encumbered.
Yes,
or
which it
they-
already is.
Or
It's a-
they have to
and-
pay off the mortgage and
That's
they
what
won't
I'm
be able
saying.
to.
But those are
What if one is
business-
paid off, then combining them eliminates
Would be
that
easier.
need.
Yes,
That's
yes.
what I
Well,
was
you're not going to be
asking.
able to do that without getting permission from your mortgagee, and they're going to
You
want to
have
be spread over the whole
mortgage.
property.
There can't be a possibility of the mortgage holder, let's say you've paid
I
off
understand.
405 and you still have a mortgage on
Still have to
407.
combine them over both properties.
Have the mortgage, otherwise 407 could be foreclosed right back out again.
Okay. That's what I was asking.
Okay,
That answers it.
okay, all right.
Okay.
Any questions, anything else? Anyone else ask? Do you want to ask for continuance?
Yes, please, can we have a continuance?
To
Okay.
the
All
November
right.
hearing?
What is the date of the November hearing?
It's third
Third
Thursday.
Thursday.
The 17th?
Yeah, and you would give us an extension to, continue the case, and then the 45-day extension after that to decide.
Yes. And what if we do decide to combine them and it takes longer to actually do that
Then you just ask for an extension.
Well, no, we could grant the relief subject to,
Subject to,
Oh,
right,
good.
right.
So-
If
so we can stick to November.
That's what we did
You know.
last time.
Yeah.
We gave them relief subject to them doing that.
Okay, I understand.
Right.
yeah. Okay, thank you.
Thank you.
Thank you.
Last appeal, Appeal 2865, the applicant Nicholas Mastantonio, property located at 558 Hill Air Road, St. David's, Pennsylvania, and zoned R3. Applicant seeks to construct an addition to the side of their residence which will not increase the existing nonconformity in regard to the side yard setback. Applicant requests a special exception pursuant to Section 280-101B of the zoning code in that the addition will no longer be no closer to the side property line than the existing legal nonconformity, or a variance from Section 280-25D of the code relating to the side yard setbacks, or contends that the relief, if permitted, as a right. Mr. Noah?
The one night that he's mellow, he's not going to hear one of my cases.
No, I've advised the board, the solicitor, the chairman, that I am recusing myself from this because of my relationship with the applicant.
The one night that you're mellow, you're mellowed out. You're not going to sit on a case that I have.
And that you had an ally on the board.
That's right. You'll have to take them to dinner next month, Nick.
I have to avoid even a specter of impropriety.
I have one other exhibit to hand up, and that's just a letter from the neighbors, the immediate adjacent neighbor, in favor of the application. And that's A11 marked.
I was going to say, what number we're going to do, A11?
Okay, is this the original one? Let's give that to.
Thank you. You're not staying? You're not staying? You can make faces in the back.
See you next time. Take care.
Just to give a brief overview of what we have here, as you can see from the plan. We're asking for basically it's a special exception relief. This is the existing plan. And you'll notice the existing dwelling is 8 feet from the property line, as is, this is an existing detached garage. That's also 8 feet from the property line. This building was constructed in the mid-1920s before zoning in Radnor Township, so it's non-conforming. So what they're doing, even though they're attaching the garage to the house by the proposed one-story addition, it still is not increasing the non-conformity, being the 8-foot non-conformity of the house. So what you're going to have here is a one-story addition, and they are going to put a second story on the existing garage, which would act as their family room. So this appears to be a 101 non-conforming addition type case. Swear him in, Norma?
You will just raise your right hand. I'll swear you in. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you. And state your names one at a time.
Nick Mastantonio.
Carolyn Carson. I'm sorry, your name? Carolyn Carson.
And you guys are married, correct?
We are.
Okay, right. And you're the owners of the subject property?
Correct.
And,
Nick?
I'm sorry,
No,
Norma.
I can't. You ask a question, they both answer. Can
Okay.
you do like one at a time?
Sure.
For the record.
Sure. I said you both are married, correct?
Yes.
And you are the owners of the property? You can just answer, Nick. Both don't have to answer.
Yes.
And I've marked as A2 a copy of the deed, and does this accurately represent the deed for the premises?
It does.
And when did you purchase it?
4 years ago.
And who do you live there with?
Our 2 kids.
And their ages are?
2 years and 3 months.
All right, I've marked as A3. This actually was the zoning for Radnor back when it was established in 1927. This actually house was built before 1927. But at that time, you'll notice that the requirement for setback was 8 feet, which is actually what this is, with an aggregate of 20 feet. So it even complied in 1927 before it was changed after that as to the setback requirements. Showing you A5, and A5 just represents kind of a photo or a plan of the property. Is that right, Nick?
Yes, correct.
Okay, and we're 558. What house number are we?
Yes, we are 558.
All right, and can you just describe what you're backing up to and what the area?
Yeah, sure. The property, it's as you can see, it's long and narrow, and we back right up to the R5 train line.
And A6 is the site plan for the property, and is that accurately represent your property?
It is.
And as I mentioned in opening, the existing dwelling is 8 feet from the property line, correct?
Correct.
And actually, the proposed addition will be further than 8 feet from the
It'll
property.
be in 2 feet, so a total of 10 feet there.
And the existing garage is currently 8 feet from the property line?
Correct.
And so you're not going to be increasing the existing nonconformity regarding the side yard setback?
We are not.
And you're not in violation of impervious coverage or any other zoning requirements?
Everything remains unchanged.
I'm going to show you some photographs. First one I've marked as A7. You could just tell the board what that represents.
Sure, that's the front of our home.
And then A8.
This is the rear of our home, and the red line's kind of indicating where the addition would go. It's not to scale, just to kind of give you a graphical overview.
And this is a one-story addition. The addition itself is one story?
That's correct.
And you're going to have a second story on the garage?
Yes.
And that's kind of what those red lines indicate?
Correct.
All right. And
So this is this.
looks like A9.
Yeah, A9 is actually taken from the rear of the property, and we're looking at the, I guess the rear or the side of the garage.
Okay, what's the addition, what are you attempting to accomplish by the addition?
So the addition's going to include really two structures, as you can see. The structure over the garage will be a family room, and the structure connecting the two buildings will be an eat-in kitchen, which we don't have. We have a very, very small kitchen today. It's not eat-in, and we don't have a family room. So it'll be an open floor plan environment where one room overlooks the other.
What's your current square footage of the house?
It's currently approximately 2,800 square feet.
And do you know how the addition, the extension here, that is one story, and that's 480 square feet, correct?
Just that structure there is 480 square feet, yes. Overall, it's going to be about a 900 square foot addition.
If you count the second story of the garage.
Correct, yes.
And we've marked as A10 some elevations.
Correct,
And
yes.
can you just tell the board what we're looking at there? Looks like there's 3 pages for the elevations.
Sure. So the first page is really taken from the side of the home, and you can see on the right-hand side of the a part of the existing garage. The left side of the drawing is the existing home, and the right in the center of the drawing there really is that building that's going in between the garage and the house. That'll be the kitchen addition.
Okay, and what type of facade is it going to be?
Yeah, one of the goals of the addition is to basically tie it in architecturally and also from a visual perspective to make it look exactly like the home. So that will all be stone to match the existing house, and it'll be a metal roof to match some of the features on the existing home.
And then part of A10 are just the rear and side elevations?
Correct.
Of the
Yeah,
garage?
just different views of the addition.
That's all I would have. Just ask the board grant a special exception on this matter, since we're not
Questions?
increasing existing nonconformity.
Brad, any questions? Pete? Jim?
No questions.
No. Anyone in the audience have anything they want to add or? No.
And just request the exhibits be made part of the record, please.
Okay.
I would propose that we grant the special exception under 28101B1 insofar as the proposed addition does not increase the existing dimensional nonconformity.
I agree. Pete?
I agree.
Brad?
Thank you.
Thank you.
Thank you.
Charlie, I just wanted to be consistent on that last one. It'd be hard. Although maybe if you weren't consistent, I would be back. I was saying, maybe if you weren't consistent.